Okay, so I expect we'll probably have a few others join us, but we'll go ahead and get started. We are here today to do a webinar, a deep dive on child custody issues. And I'm here today with Michelle Dellino from Dellino Law Group, who I will let introduce herself in just a moment. I'll just tell you who I am. I'm Melissa Rosenberg, and I'm happy to be working here alongside Michelle today. I am a mental health provider, and I provide mental health services and therapy services, both individual and couples therapy, to people who are dealing with life transitions, relationship transitions. And so I'm happy to be able to support a lot of clients through their family law cases, including child custody issues. That's pretty prevalent among many of my clients. And I'm here today to just help moderate and also take any questions that might be relevant to the work that I do. But the meat of what we're going to do today is talk about child custody issues. And Michelle's going to present some information about child custody. And then we're here to also answer questions that you might have. So if you do have a question, I just want to encourage you to go ahead and pitch that to us. You can do it in a couple of different ways. You can put your question in the Q&A. And I believe there should be an option if you would like to post your question anonymously, or if you want to have your name, it's totally up to you. But you can put your question in the Q&A and we will make sure that we get that answered. You can see the Q&A option on the bottom of your Zoom screen. You can also choose to put it in the chat if you'd prefer. And if you do put it in the chat, I don't think there's an option to be anonymous, but it will only come to the panelists. So a question that you put in the chat will not go to the other attendees of the webinar, and it'll just come to us. So either way, we're welcome to see you're happy to see your questions in either format, either the chat or the Q&A. We'll answer as many of those as we can, present some information, and then we'll send you back to your day. But we're happy to have you join us today. And now I'll turn it over to Michelle, and maybe Michelle, you could give us a brief introduction of yourself.
Sure. Hi, thanks for joining us today. I'm Michelle Dellino with Dellino Law Group. I am a family law attorney, and I operate a family law firm that has offices in Seattle, Bellevue, and works all around the Puget Sound. We find that one thing that is so clear about family law is people don't have enough information, or they go to Google and they look for things, and there's a ton of conflicting information, some of which is not about Washington family law at all. So we do these webinars as a way to give people information, let you ask some questions, and because it's fun. So one thing that comes up in every webinar that I ever do is custody questions. And so what I thought we would do today is kind of delve a little deeper into some custody issues that we never have time to talk about otherwise. Some of them might not be relevant to your situation, some of them might be, but I think it's a great idea to go there, because if you have children and you're going through divorce or separation, custody is literally one of the most important things, if not the most important thing that you're going to deal with if you don't have an agreement with the other parent. So on how to proceed. So that's the gist of what we're going to talk about. What I'm going to talk about first is parenting plans in general, and give a little bit of an overview about that, and who needs one, when you need one, what the situation is, because that might be a term you've never even heard before. Let's talk about parenting plans. What is a parenting plan? Some people in other states call it a custody order. In Washington, we don't call anything a custody order. We just have parenting plans, and that is, like it sounds, it's a plan for where your children are going to live, who is going to have certain holidays, who's going to make decisions, how you're going to make those decisions, and all of those related issues. So decision making is one part of a parenting plan that a lot of people don't think about when they start a divorce. But a parenting plan is a court order. So it's really important for you to know that once there is one in place, you have to follow it unless the parties agree not to. So who needs parenting plans? Well, a couple going through a divorce needs a parenting plan, but parenting plans also apply for unmarried couples as well. So if you're an unmarried couple, you might need a parenting plan with the residential schedule to establish what's going to happen, because otherwise, you could not have anything in place for a number of years, and that could be a problem for you. So parenting plans are utilized by married and unmarried couples. That is something you need to know, and they are court orders. Another thing to know is that sometimes if you're an unmarried couple, this comes up a lot. If you're an unmarried couple and you need to establish whether there is actually parentage established, and that's a legal term. So you need to determine whether there's parentage established before you can get a plan in place. And that just refers to what parents are on the birth certificate. And if that's established, if that's not established, whether DNA testing needs to happen. But a parentage action also can give rise to a parenting plan. It usually does, and it usually should, but sometimes parentage is a precursor to that. So that's just something good to know that a lot of people don't even realize. You can't have a parenting plan unless there's parentage, even if you've been parenting this child for years. So it's very easy to establish, and it's a requisite of parentage actions. When do you need a parenting plan? Well, this is the thing. There are two kinds of parenting plans that we're going to talk about. One is a temporary parenting plan, and that is different than a final plan. A temporary plan is something that goes into place when a case starts, or essentially to establish a status quo and a new normal for people while they're going through the divorce or separation process. A final parenting plan is something that's entered at the end of the case when you finalize with final orders, and that final parenting plan will be what you follow from there on. We'll talk about changing parenting plans too, but let's talk right now. For right now, I want to focus on talking about not just changing them, but how to establish one and what you need. So one thing people ask often is my temporary plan going to be my final parenting plan? And that is definitely not always the case. Sometimes, because sometimes you have a temporary plan and it works really well, and the parties agree that they want to go with that to finalize and just add additional details. Another thing to know about a temporary plan is that it definitely does not include usually all the provisions for the holidays or all of the provisions that you're going to need moving forward. It is what it sounds like. It's temporary and it gives you a new normal, but it is not meant to be final. Sometimes you'll decide, generally we want this as a final plan. Other times you might do something totally different, especially if one parent is looking to relocate. Whether it's just out of the school district or out of the state, your final parenting plan could look very different. Parenting plan can also look very different on a final plan if you have a parenting evaluator or guardian ad litem doing an investigation during your case. That could very easily change the outcome. And sometimes there's a reason that you're having that person do an evaluation, and it is because you either aren't happy with a temporary plan, or you think both parties think there's going to need to be more information before there can either be a settlement on a final plan or a court can make an informed decisions. A lot of the time the court likes to see a parenting evaluation or guardian ad litem evaluation or some kind of custody evaluation, which can also be family court services, if there's not an agreement on a final plan, because otherwise there's just not a lot of information to go on. And we'll talk about those evaluations as well as part of this program today. So temporary plans, final plans, not always the same. Married and unmarried couples can get them, parenting plans, and you really kind of need one, because otherwise it can put your child in the middle of conflict that can go on and on and on during a case, and you really literally don't want that. Let's talk about high conflict issues for a minute, because a lot of the time, if you're looking at a plan and the other parent is high conflict, you're going to have other considerations that you may not have in a different type of plan. So what does it mean if you have a high conflict situation? That doesn't mean the same thing to everybody, but it means like it sounds. There's a lot of conflict between the two parties, and communication can be difficult, and that can filter down to questions about exchanges in the parenting plan and many other things. So I always like to talk about in a high conflict plan, what are some things that you can put in there, and what are some things that you can do to make things easier? If you're the high conflict person, well, then that's another thing, but let's just assume that nobody here is the high conflict person. Sometimes there's two high conflict people, and that's a whole other thing too. So I'll give you some general basics. Communication is dealt with in a parenting plan. So you talk about not only where the kids are, but how are you going to communicate about them if necessary. And sometimes some parties are so adversarial, they really can't even speak very well without it getting kind of off track and impacting the children. So in those situations, I recommend provisions that ask for communication to be tracked through Our Family Wizard or Talking Parents. Those are two applications that are really common. Our Family Wizard is what we kind of call the gold standard plan app because it's the most commonly used and it has the best features. I really wish somebody, so if any software developers are listening, develop a parenting communication application that's better than our Family Wizard, and everybody will probably use it. Our Family Wizard's good, but it's not great. So what it does have, it has the ability for both parents to communicate. And when someone reads a message, it will track it and say that it's been read. So if somebody can't say, hey, I didn't get your email, your text didn't go through, that our Family Wizard takes that off the table. Number two, there is a shared calendar that you can utilize, which is really helpful when you're establishing a new normal and even beyond in tracking activities for your children and not having to communicate with the other parent, just saying, hey, I'm putting it on the calendar, and it's a shared calendar. There is also a tone meter in our Family Wizard, which is a fabulous tool. And if it's turned on, then if somebody's tone in messages is super high conflict and hostile, it's going to pick up on that and it's going to track it and it's going to tell you to stop. So that's another really good thing. Our Family Wizard is great too, because then you don't feel like you're constantly being bombarded from other messages in your day-to-day life from somebody that may be high conflict or stressing you out. So that's something that can go in a high conflict plan. Other thing that can go that's really important about custody and parenting plans that I touch on in high conflict situations and every situation is clarity in the exchange points and locations. You want to make sure that your plan is going to talk about where the exchange is, when it is, like actually what time it is. If it's going to be at school or daycare, if school or daycare is not in session, you want to make sure that you have a neutral location specified. So it's super clear where that's supposed to take place if you're not doing an exchange or a handoff at school where you normally would. That is definitely got to be in there. It's also where you would determine if the picking up or the dropping off parent is responsible for the exchange and the driving, or whether the parties are meeting in the middle at a neutral location. That's another thing I recommend in high conflict plans. It's what we call the Starbucks or McDonald's exchange, where there's a designated location. One parent goes in with the child, gets them a Happy Meal or cake pop or kids cocoa or whatever you like. And then when the other parent comes, kid has that positive association, gets a little treat, other parent comes right outside, kid goes out to the other parent. So that way the parents don't interface and it creates, something to for the parents to look forward to. So that's just something else you can put in your plan. Before I move on to talking about residential schedules and parenting plans, Melissa, do we have a question? You're on mute.
Every time.
I know,
somebody did just pipe in and saying, how do you request that to the judge?
Good question. Well, I'll tell you this briefly about parenting plan actions, whether it's in the context of a divorce or a separation. You can request a temporary parenting plan, and you can do that through agreement. But if you want to do it with the court, you need to file a motion and actually get a motion before the court. And then you have a proposed plan, which is going to have, hey, I want all those communication issues in here, and this is why I want this schedule. And then you submit your proposed plan, and then you go to a hearing, and the court decides. So either setting a hearing on a temporary plan or on a final plan, if the court's deciding, they're deciding in a trial. So then you're in a trial and you're presenting to the court what you want. So you can ask the court for those kinds of things, but it's always better, in my experience, if you can negotiate to work it out with the other party first, because if you can do that, you have control over what's in there. I can't stress enough to everyone that you can go to a hearing. Party A could ask for this parenting plan, party B could ask for this parenting plan. You both might have different provisions you want. And sometimes the court will say, yep, I'm going to go with party A with a few changes, or party B. Or sometimes the court will be like, I hate both of those ideas and I'm going to come up with my own thing completely. And I've seen that happen. And then nobody gets what they wanted. And that's always a risk, because the court is the last word on the parenting plan entered. So definitely ask for it in a hearing if you can't negotiate it. But try to negotiate it first if possible, so you have control over what's going to be in there. Okay. Anything else, or should I go on, Melissa?
Maybe I'll just say a couple words about some tips that I have around
that would be great.
High conflict co-parents.
That'd be great.
I think it's extremely challenging, and I work with a number of clients who struggle with somebody that they're either in the process of separating from, or that they're already separated from, but who generally bring a lot of conflict and they have to deal with on a regular basis because of child custody issues. And some people will say, oh, my ex is a narcissist. That's a very common thing that I hear. And sometimes they are. actually somebody who qualifies for narcissistic personality disorder, and sometimes they're not. But what people are usually saying is they're controlling, they're manipulative, they are entitled, maybe they lack empathy, maybe they're self-important, maybe they have power issues. That's usually what someone is trying to say when they're saying my ex is a narcissist. But I think that those are, in general, people who are exhibiting those traits are really very hard to deal with. I mean, obviously, I think top issue that I will, of course, always say is if it's ever an unsafe situation, and be sure that you're mindful of that. But without going to that extreme, just dealing with a difficult person, um, be prepared. Know who you're dealing with. If your former spouse or the co-parent has been, controlling and manipulative and entitled, remember that, and use that to inform your own behavior and your own approach and how you're going to deal with all these things. Knowing that, and that this is going to be a difficult situation, be sure that you have a support network in place. Have people around you, surround yourself with social supports who understand you and who you trust and who are supportive to you and your children and have their best interest in mind. Consider having a therapist to support as well, because this is tough and it's going to be tough for a while, most likely. And it's helpful to kind of have a space to really process those emotions and deal with your approach and how you're dealing with conflict, so that you can, work things out to your best interest legally as well. Be ready to set limits and boundaries with somebody who is high conflict. Be ready to set and hold your limits and boundaries, not just set them and let them be mowed over, but set them and hold them. And that's where your support network and your therapist are really going to come into play to help you assess how well you're able to kind of set and hold those boundaries. Be kind of cautious and mindful and strategic in how you're going to communicate, and use your attorney to communicate. Use our family wizard, like Michelle talked about. Use opportunities to engage that are going to avoid getting you into a toxic communication spiral. If you've been in a relationship with this person, or you've been trying to co-parent with them for a while, and they are this high conflict, there's probably been a toxic communication loop that you can find yourself getting wrapped into. And so you want to really avoid that by setting boundaries, by being strategic and mindful in how you communicate, doing things in writing, like through our family wizard, having a strong attorney advocate on your side to really understand the right way to approach these things from a legal standpoint, and a therapist on your side to help understand how to approach these things from an emotional standpoint, and to sort of check your own emotions and dealing with these high conflict situations. So those are just a few things that I wanted to throw in there that I think could be useful when you're dealing with a high conflict.
Those are great. And a lot of people end up in that situation. So that's really helpful. It's also really helpful to utilize a therapist if you have one, or if you don't, to get one that knows these issues, because I can't tell you enough how people's attorney fees get really high in custody disputes. Number one, because sometimes they need to, because there's a lot of work to be done, but also because they might be talking to the attorney about issues on how to cope. And while we love to talk to you about that, it's more cost effective for you to talk to a mental health professional. So that's just a note. I do want to talk about establishing a parenting plan and what the court considers in doing so. And then I want to talk about relocation. So those are two issues I never have time to talk about. So I wanted to do that today.
And Michelle, we do also have some questions coming in already. So let me know when you want to take a pause and grab a few questions. Okay.
Okay. I'll take a break in a couple of minutes. That sounds good. And answer questions. That's more important than what I have to say. But when we're looking at establishing a parenting plan, what goes in there? I want to talk about that and what the court considers. The court looks at the residential schedule that everybody knows, and currently that's section 8 of a parenting plan, and that's going to say where your kids are. And then the court looks at the dispute resolution section. The court will not put a dispute resolution section in your parenting plan if there are what are called limiting factors. So I want to talk about that. So let's talk about limiting factors. Those appear in the beginning of a parenting plan. So if one of the parents has a problem with substance abuse that impacts parenting, if a parent has ever had a finding of domestic violence against them, if a parent has neglected a child, these are some of the very common bases for restrictions in a parenting plan. And there is typically typically a finding made that has happened. There can also be findings for things like abusive use of conflict, which means one parent has abused conflict and made it worse, and things of that nature. There can also be other kinds of findings that are not as common. You might have someone have an addiction even to something like pornography, and there may be a nexus that finds it interfered with their parenting. And mental health is another issue. If someone has a mental health issue, it doesn't mean that because you have a mental health issue, you have a restriction. It just means if it affected your ability to parent, you may have a restriction from that. So if there's a restriction, a couple of things happen in a parenting plan. One, dispute resolution can't be ordered unless the parties agree upon it. So that means if the parties disagree about the parenting plan or decisions in the future, then they need to go to court to deal with it. The reason for that is if a parent has a restriction, it can make it really difficult to engage in dispute resolution. So that's number one. The other thing that can happen is a restriction is a basis for limiting residential time. In some cases, that can mean a parent starting on supervised visits or staying on supervised visits until certain things and thresholds are met. In other cases, it can mean just you have less time for whatever reason. And then finally, another major way that it impacts things is in decision making. Decision making is the other huge thing in a parenting plan aside from residential time. That is who's going to make decisions. Like when you're not living together anymore, you'll need to make educational decisions for your child, where school they're going to go to, what, when they go to school, if they can take time off school, all those kinds of things. And then you're going to make decisions about non-emergency healthcare. The big ones that really come up are things like orthodontia at a certain point, braces, that kind of thing. Scheduling appointments, whether your child can go to a counselor or a therapist is non-emergency medical decision. Basically anything about your child's medical care, except for my child is sick right now and needs to go to the ER or whatever. And then other major decisions that come up as well are extracurricular activities. And if parent A wants their child to play soccer and parent B says no, how do you work that out? So you really need to know whether both parents are going to share those joint decisions, or if there's restrictions if one parent is going to be making all of the decisions. So that's something that's really important. When we talk about custody schedules, people call them custody schedules. It's actually called residential time. We use friendlier terms. I like to say that. There are traditional schedules where maybe one parent has most of the time and the other parent has a week on, week off. There are schedules every other weekend. There are schedules where parents share equal time and they have week on, week off. There are schedules where a child might be younger, and so week on, week off is too long to go without seeing one of the parents. So you might do what we call a 2-2-3, 2 days with one parent, 2 days with the other, and then rotate a 3-day weekend. There are a multitude of schedules that you can come up with. And so knowing how to come up with a schedule that's appropriate developmentally for your child is really important, and that's going to work for your life. And in a final plan, it is extremely difficult to change a parenting plan. You have to have a substantial change in circumstances that wasn't and couldn't have been contemplated at the time the plan was entered. Those can be things like one of the parents has moved. That's a relocation issue we'll talk about. It can be something like it's detrimental in one household to the child. So it has to be a change of circumstances with the other parent or the child to change a parenting plan, and the threshold is high to establish that cause. So you want to be really careful about the schedule that you come up with and make sure that it works for you. That's why it's very common for schedules to be negotiated in mediation, because then there's back and forth between the two sides to figure out what the schedule is going to be, how it's going to work, what are the days going to be. It's also really common with younger children to come up in a final plan, not a temporary plan, but a final plan will have phases. So phase one, while the child's young, it might look like this. When the child's a little older, it might look like this. And then when the child's a teenager, it might look like this. And that also is the same for designating vacation time. Maybe the parents take more vacation time when the child gets older. There are any number of things like that, but it's important to know these are all components of a plan. And if you can't figure it out by agreement, the court is eventually going to decide. Although most cases are not resolved at trial, they're resolved through arbitration, mediation, negotiation. Only about 10% or less of cases actually end up going to family law trials. So that's something for you to know and be aware of. Relocation cases, I think it's really important to talk about relocation cases. This is something that absolutely happens in the middle of a case and after a case. One party wants to move. And if one party wants to move, there is a statute in Washington state that says, if you're moving outside of the school district, and that can be not that far, or it could be really far, you have to give notice to the other parent. You have to give a 60-day notice that you're going to move. You have to say when. You have to have a plan for where you're going to move and all those kinds of things. You can't just say, hey, I want to move someday. You want to say, this is where I'm going to move. This is my plan. And there's different points in your case when it's appropriate to give that notice and when it's not appropriate to give that notice. It's not appropriate if you really have no plan to move and you're just trying to create a change and you're going to change your mind later. That's going to have you paying attorney fees. Don't do that. It's appropriate to give notice when you don't have an emergent situation and you give more than 60 days or more of notice. If you have an emergent situation, you just found out and you couldn't have known that you need to move, like your job says, you got to move, ASAP, you can give 5-day notice from the time that you find out. So there are other circumstances that can trigger a 5-day notice requirement, but it's generally 60 days or more. And then the other party has 30 days to respond and say why they object. And the court will evaluate a number of factors. So relocations can happen after a final parenting plan is entered or during a divorce. If it's during the divorce, typically what will happen, rather than a notice requirement or anything like that being a major issue, is there will need to be a custody evaluation. So the court can be well informed and the parties will have a recommendation on whether the move should happen or not. Melissa, before I start talking about parenting evaluators and guardian ad litems, are there some questions? I think you said there were.
Yep, I got a couple questions here. Question that was pre-submitted and asked again here today. It is, if one ex-spouse remarries or cohabitates with a new partner and their combined income becomes higher, will that ex-spouse have to pay more child support?
No, no. I'm glad that was asked. That's something that comes up. So let's talk about that for a minute. The only factors for child support are this. They are the income of the parties, the age of the child, and the county that the child lives in. There's a statutory calculation that gets done of parent A and parent B's incomes. And once you do that and you figure out the deductions, we can tell you how much the child support obligation is going to be and who's going to pay what portion of it. If then, let's say parent B gets married and that person makes more money, so their household income is higher. If one party was trying to adjust support, that would need to be disclosed, how much that person makes, but it's not a factor and it isn't going to change the child support calculation. However, let's say, and this does happen, this is the only real time that it matters. Let's say there's a child support order and parent B says, hey, we have a 50-50 parenting plan and I want what's called a deviation in my child support. And a deviation means I want to deviate down from what that standard calculation is based on our incomes because I have the child a lot. And then let's say the other parent says, I can't afford that because not being able to afford less child support in one household is a basis to deny a deviation. So let's say the parent's saying, I can't afford it, but that parent has been remarried or lives with a partner that has an income, and then the court sees that house makes $20,000 a month between two people, the court's going to say you can afford a deviation, as opposed to one person, let's say, was living there and making $5,000 a month. It might be a lot harder for them to afford the deviation on their own. So it can be considered as a factor whether or not to grant or deny a deviation if there's another party in the home making money, but it does not raise or change the child support calculation. Only the income of the parties can do that.
Okay, thank you. Another question in the chat is, if we agree to make changes to the parenting plan after it's been finalized, does it need to go to court to be revised, or can we revise it on our own so it's in writing?
No, you can't do it. I mean, you can do it on your own. You can do whatever you want, but it's not binding. So what you need to do, if you like, let's just say, okay, I'll tell you this. This gets into modification a bit. So if you have a parenting plan and it's final, and then you guys can still make other agreements. So let's say parent A and parent B have a week on, week off schedule, but for a period of time, one parent says, oh, I need to do something different for work, and you guys agree that you're going to operate differently, that's totally fine. Every time you do something different, you don't have to tell the court. But if you want to change your parenting plan, you actually have to change it. You can't just write it down and say we agree. That's a factor that could be considered later. But at any time, the parenting plan could be enforced. And if you don't actually modify your plan, you don't have a parenting plan that says that. So you want to be really, really careful about that. If you have an agreed modification, that's actually pretty easy. And all you need to do is do the agreed modification paperwork to modify your plan and enter a final plan. If you have a schedule you're going to deviate from for a little while, you're totally fine. And I don't tell people that you got to run out and modify your plan. But if it becomes a long-term thing, or we absolutely want to change the schedule, just do a new parenting plan and modify it so it doesn't become an issue later. I've had cases where this exact same thing happens. One parent does what we call integrate the child into their household by adopting a new schedule, and everyone thinks it's fine. And then eventually other parent says, hey, I changed my mind, even though we have an email saying we agreed to it and we've been doing it. And they try to enforce the plan. And then we get into whether the other parent has to actually seek a modification based on that integration into the household, whether that's going to be granted. It can create a lot of problems later. So if you have a new plan, just get a new plan done. And if you agree, that's really easy. And there's not a need for you to appear in court, just to make sure that you do the paperwork properly for an agreed modification. I hope that helps.
Yeah, thank you. Okay, somebody's asking if I want to use our Family Wizard, how do I set that up or use it? How do you go about
That's
doing
an easy question. Our Family Wizard, and I don't get any money from them, so but our Family Wizard is $99 a year, I think, for each party. You can sign up online. The first parent to sign up, you put in the other parent's information, and it will send a request for the other parent to sign up. A really nice thing about our Family Wizard, or OFW as we call it, is you can also give access to an attorney to have like a read-only option. So if your attorney needs to read OFW for you or see what's going on, they can do that. But you got to either make sure that both parents are in agreement to use it. Because if you sign up and pay for it, the other party might say, hey, I don't want to do that. And the court usually will order it if it's a fairly high conflict situation, or even if it's just a situation where one party wants it, the court likes it. So it's not a huge financial burden, but you can sign up for it. It will send an invite to the other person. And if you don't have a parenting plan yet, then you can try to make that part of your parenting plan. If you do, you could always still get an agreement to start using it. I think it's actually a really good tool, and it limits a lot of back and forth. So
yeah, it seems like a wonderful tool. A number of my clients use it and really value the ability to kind of have some control over the communication that way. Let's see, kind of a sensitive topic that came to me in the chat has to do with a participant is saying that the other party texted and took a picture of the child's private parts in an attempt to show them a rash, right? But it bothers them that there was a picture that was taken, of a sensitive area. And so I'm just wondering, sort of maybe to frame that in a question, what's the best way for maybe the parties to communicate when trying to show situations like that, maybe through the doctor?
Well, I think if a parent said, hey, there's a rash on my kid's butt, and they took a picture of the kid's butt and the private parts are shown or whatever, that's going to happen. That's parenting. If it makes you uncomfortable and there's a reason why, or it keeps happening, that is something that you might want to discuss with an attorney if there's a reason to really be concerned about this. But it's pretty normal for parents to share pictures of rashes. There's not really like an easy way around that. If you're not comfortable with it, just tell the other parent, but then the other parent might be like, well, why don't you want to see what's going on with the kid's medical issues? So you want to know, is there really another issue here? If there is, definitely bring it to the attention of an attorney or the court and get some advice on what to do in your certain situation. But otherwise, I think it's better to err on the side of having the medical pictures and information and documentation. The other parent might not realize it's bothering you.
That's true too.
Yeah.
Okay. Any advice or sources of advice or even templates on plans for teenage kids? High school age they're talking about.
Yeah, that's a good question. A lot of that depends on how close you live to each other. A lot of people like to progress to a plan that is a week on, week off, 50-50 when the kids are older, because you don't need to see, it's easier for the children to be away from one parent for a whole week, and it allows them like really consistent schedule, 1 week at mom's, 1 week at dad's, or whatever your situation is. So that's really common when kids get older. But to make that work, the parents need to live close enough to the same school to make it work. You're not going to have a 50-50 with one parent in Tacoma and one parent in Bellevue. Like, that's not going to happen. It's not realistic. So other plans can just be the traditional every other weekend with one parent and maybe like midweek dinner or midweek overnight. But when kids get older, they really care more about their routines than their parents, is what we find. And so they love their parents, but they really just want to be where it's convenient for them to do their activities and see their friends. And you want to make sure also that both parents are equally involved with what's going on with school and activities. Because if you have a child doing a week on, week off, and they weren't doing that before, and one parent is not, keeping up while the child's in their home on schoolwork and things like that, it can create a real problem. So it really depends on your own situation. I mean, there's a ton of 50-50 plans. There's a site called Custody Exchange people like to go to. I think Custody Exchange, it's like letter X. I don't know off the top of my head. I don't use it, but I like to show it to people sometimes just because they need a visual for what these plans look like. It's just basically shows you color coded who gets what days, and you can put in different time scenarios. I think 50-50s are good when kids are older if you live close. If they're not, I think it's better to have a plan where there's more consistency in one parent's home, just because of all the activities that are going on, and the child kind of needs a stable home base. So it really depends on your individual situation, but there's a lot of options. And it's actually easier. Co-parenting is easier when your child is older because they can help with their own transportation. And a lot of the time there's just activities going on. So it's a lot easier than when you have a really young child and that child needs to basically everything done for them.
Great. Couple more questions here.
Yeah.
What if the other parent moves, but the move is still within the same school district? Do they need to provide a 60-day notice?
No. Most parenting plans will just say that you need to provide current address for where the child's going to be living. So it's like, hey, I know I'm moving. I need to give a current address to say where I'm moving and give them notice. Sometimes you might put in your parenting plan, you'll give 30-day notice or whatever, but that's just in your parenting plan. It's basically just like update me when you have a new address. But you don't need to give any kind of formal notice or seek permission to relocate with the child the way you do when you're moving outside of the district. So the answer to that is no. Same with non-residential parent. And when I talk about non-residential parent, I just mean the parent who does not have the child the majority of the time. So in a situation like that, that parent still needs to tell the other parent where they're living. They just don't need to, if they're moving, they just don't need to give a 60-day notice. And a parent, this comes up often too in parenting plans. Let's say parents A and B have a plan and it has like a Wednesday to Thursday overnight every week for mom. And then mom moves from Seattle to Portland for her job. And she's obviously not going to be able to have that Wednesday to Thursday overnight every week. But let's say she doesn't have the majority of the time. She could bring a modification to change the parenting plan based on the fact that she moved and she can no longer do the Wednesday to Thursday. Maybe she just wants longer weekends or more time in the summer. So there can be a lot of different reasons to change a plan. Yeah, but you don't have to give notice of 60 days if you're the non-residential parent or if you're moving, still within the school district. And that can mean a big area. Like if you live in Seattle schools, you could move from up by Northgate to West Seattle and you really technically don't have to give notice.
Okay, so even if it's in the same district but a different school, they still don't have to give notice. Okay.
Correct. Yeah.
Okay, a little bit off topic, but do you have any tips for low or no cost legal representation if the other person has an attorney and maybe you can't afford an attorney?
Well, if the other parent, depends on if you're married or unmarried couples and what the situation is, but the options for what we call pro bono or low bono family law representation are extremely limited. Their Washington State Bar Association does have what's called the moderate means program. You can go there and some attorneys will take clients on sliding scale or flat fee matters. So that might work. You could definitely do that. And see if there's anybody there that can help you, but there's long wait times. King County Bar Association Neighborhood Legal Clinics provides free 30-minute, usually 20 or 30 minutes, depending on the clinic. I volunteer for family law clinic, and so we will meet with clients just to give limited advice, for free 20 or 30 minutes, you can do that. You can keep coming back to the clinic if you're working on something. But if you're in a divorce and one party can afford fees and the other can't, you should be seeking fees, because fees are granted on a need and ability to pay standard. If you have a need and the other party has the ability to pay, Title 26, which is the Domestic Relations Chapter in Washington, makes it very clear that that's the law. So you could seek fees. It's not right for one party to be able to pay for fees and you not to be able to have them. That doesn't always apply with unmarried couples, though. So that's something to know.
Yeah. A few more questions, both in the chat
Okay.
and Q&A, about child custody issues and child support also. Is child support based off of percentage time with the child? For instance, does the primary parent get the same amount whether they have the child 50% of the time versus 90% of the time?
That's a good question. Yes, they do get the same amount unless someone seeks a deviation. It's definitely not percentage of time. Some states will do it like that. We don't do that. It's just basically parent A, parent B, you have a statutory calculation, and the residential parent gets the portion of that child support number from the non-residential parent. It doesn't matter like if you have 90% of the time or 60, it really doesn't matter. However, there are reasons you can seek a deviation, and the most common one is time spent with the child. So if you have a 50-50 that the other parent, the presumption is that the one parent still pays support to the other. But if you have a 40% of the time or 50% of the time, one parent might seek what's called a deviation. So a credit against the support to reduce the support because they have the child a lot in their home. And there are, like I mentioned earlier, there are bases to deny a deviation. And a most common one is the other household can't afford a deviation. So, but as a rule of thumb, there's no automatic deviations. Deviations are granted by discretion. So there's no guarantee you're going to get one, and your child support is essentially the same whether you have 90% or 60% or whatever.
All right, thank you. Any suggestions for establishing some sort of visitation when parents live across the country? So seeking having the child closer to maybe 90 days or 60 if possible during the holidays or summer vacation, something like that.
Yeah, long distance parenting plans are really common. Actually, we do a lot of them. And it depends on if you're talking about just on the West Coast where you're a couple hour plane ride from California, or whether you're talking about Florida or Miami, which is a totally different situation. If you're talking about across the country, it's really common for the non-residential parent who lives further away to have most of the summer. That's completely common. And to have maybe the majority of breaks. So maybe they get, and this can be different, but let's say if there's a 10-week summer vacation, they might get 6 or 7 weeks. There's a 12-week, they might get 8 weeks. If they might get every spring and midwinter break, so those are really common ways to deal with a long distance situation. If it's a situation where the parties have resources and it's just, Oregon or California, Northern California, and one parent can afford to travel, they might be able to have the option to exercise a residential weekend in that area where the child is if they give notice and go for it. So there's different provisions you can do depending on your situation, and also too, depending on the age of the child. If the child's younger, up until the child is school age, you could obviously give the parent who lives elsewhere a lot more time because the child's not in school. So, yeah.
And then another question here is, if traveling via plane to another state or country with the kids, do we need a letter from the other parents saying it's okay for the kids to travel?
Other state? No. It depends on what your parenting plan says.
Yeah,
Parenting plan
would be in the parenting plan.
Yeah, a parenting plan will deal with international travel and interstate travel. Generally, if the parents agree, a really common provision that I usually put in my plans is if child's away from home more than 2 nights in a row, you have to tell the other parent where they're going to be staying. Or if you travel out of state other than the border states, then you need to give X amount of notice just so the parent knows the kid's going to be out of state. But I usually will say, like, if someone's going to take, the child to Oregon or Idaho, they're probably maybe they're going for a weekend to go camping or a quick last minute trip. It's kind of unreasonable to require like a 30-day notice for that, or even BC. So I usually require a shorter notice time for that if the parents agree, and then a longer notice time for out of state travel or away from home more than 2 nights. But you don't need to give permission. Like, anyone can take the child on the plane, and that's normal. You can expect questions like from security sometimes, just to make sure that the child knows they're supposed to be with you and that you are mom or dad, but you don't need any notification. I'm sorry, you don't need any permission. That's different than international travel. Parents have to actually go together and cooperate in getting a passport for a child. So, and then a parenting plan will usually dictate who holds that passport, how much notice needs to be given for international travel. And then usually a travel consent will need to be filled out that you'll need to travel with your child. So that's a little bit different. And those are elements that go in a parenting plan, and typically in section 14, which deals with other provisions. That a good parenting plan should have that. It should also dictate whether you can take the child to what are called non-Hague Convention countries. Those are places like Russia, India. If you go to a non-Hague Convention country, which is a country that's not signer to the Hague Convention, United States parenting plans are not enforceable there. So if you were worried about a child going to India, there'd be no way to get them back, basically. And a lot of the time your parenting plan should just say that won't happen unless there's family there or a really good reason.
I'm not sure I understand.
All right. So I don't have any more active questions right now. We've had a lot of great questions. If you do have any more questions, please go ahead and put those in the chat or the Q&A now. And Michelle, I don't know if you had another set of topics.
Yeah, the only other thing, I mean, there's a lot, we've covered actually quite a bit and we don't have a ton of time left, so I'm not going to start a whole other section. I will say this, it's really important when you're thinking, oh, I wanted to talk about parenting evaluators, and that's what I'll talk about before I wrap up with my stuff. So if you're in the middle of a parenting plan dispute, you're probably going to want a custody evaluator. I've mentioned that a few times. And there are parenting evaluators, which are usually PhD or PsyD candidates, holders or higher, which can do a psychological component of a parenting evaluation. And they're going to be evaluating the parents and making a recommendation and meeting the child or children and coming to the home and doing those things. A guardian ad litem is a little bit different. A guardian ad litem can be a PhD level or higher, can be master's level, can be an attorney, and that is a person who stands in the shoes of the child, does a custody evaluation, and makes a recommendation. There's not always psychological testing with a guardian ad litem. There may be a request for that to happen, but either one, it just kind of depends on the needs of the case. Parenting evaluators are a lot more expensive too, so that's not always an option for everyone or even really necessary, but it can be very helpful. And so a lot of the time when there's not a certainty on what's going to happen, then you either need to work with a custody evaluator that gets agreed upon and appointed, or you may have a situation where family court services is appointed to do an investigation. The family court services investigation can take a really long time because they're very backed up right now, but they also do evaluations of situations. And so it's important to know that an evaluation, whatever is said, is not the last and final word. It's completely possible that you can challenge one of those reports, but courts do take those reports very seriously, and they look at what was recommended because that person has spent significant time evaluating the situation. So that's something that really is an important component of custody, and knowing who to choose, when to choose them, and doing that is all something that you should be aware of. So if Melissa, are there any other questions?
Yeah, there is one more question.
Sure.
If decision-making is 50-50 and both parents' names and consent have to be on every form, if one parent wants to open an investment account for the child with their own money, do they also have to ask for the other parent's permission?
No, not at all. A very common example of that is like a 529 account. Those are often set up, and a grandparent can even set one of those up, or anybody can for a child. If one parent wants to set up like a savings account or whatever and put the child on it, that's not a joint decision. Financial decisions aren't joint decisions unless they obligate the other parent. So no.
Okay, great.
Yeah. Last thing I was just going to say about parenting plans in general to know is your parenting plan, I've said this multiple times, will be very difficult to change if you want to change it. I can't stress to you enough how much you should not just download something from the internet and start filling it out, because most of the time those are the situations where you didn't know what to think of, which is totally fine. And then we will have conflict over that later, and it could have very easily been avoided, or someone wishes they could do something differently or change it. Also too, saying that there's no restrictions in a parenting plan when there should be, or where there can be other language that can be used to reserve that issue in some way, is really important. So it's critical. Your parenting plan is critical that you pay attention to detail, and that you get some advice on it, even if you're not working with an attorney. I highly recommend it. The number one problem we see later, it comes from people not having a good parenting plan in the first place, and then having a really hard time changing it later. So that's the last bit of advice I have today.
We have one more question. I think it's a really good one to end on.
Okay.
Can therapy for the children or the parents be included in the parenting plan? If the parent has an addiction, can we request that they go to therapy even if they don't think they need it? So how can those kind of provisions be put into a parenting
That's
plan?
great. Yeah, well, it's like I talked about earlier. If the parent has an addiction and it's impacting parenting, then you probably want a limitation. And a limitation will typically have a request for therapy, treatment, whatever. There'll be something in there. And if they're not going to agree on it, then it's going to be a decision for the court to make. But yes, it's completely the appropriate place to ask for that relief.
Yeah, absolutely. All right. So we'll go ahead and let everyone get back to their day. We have been able to answer a lot of questions today. I put up a slide here with contact information. If you are interested in contacting one of us, please do that. Here's our contact information here. And yeah, we try to do webinars monthly. We also do a meetup group once a month on the last Wednesday of the month in the evening. You're welcome to join us there. You'll get a follow-up after this as well. And we really appreciate you coming today and sharing your questions. Sometimes if you don't have a question, it just helps to hear what other people are asking because you're not sure what to ask. So I think coming to these things and involving and gathering information is fantastic. So thank you so much, everyone. And if you can also go to our website, dellinolaw.com, for more information. There's a lot of information on our website, a lot of information about our team and about our firm. So please go ahead and check that place out, the website out as well, or give a call or an email to either one of us.
Hey, thanks for coming. It was great to have everybody here. Take good care. Have a good day. Bye-bye.
Take care.